Welcome to Law, Life, and Liberty with Anthony Puopolo.
Welcome to Law, Life, and Liberty with attorney Anthony Puopolo. Anthony G. Puopolo II is a Massachusetts attorney who helps families navigate divorce, custody disputes, and criminal charges that often overlap. With offices in Lowell and North Andover, he's represented clients across Middlesex, Essex, and Suffolk counties in both family and criminal courts. I'm Lisa Mosby, your host, and today we're talking about understanding your rights in Massachusetts after a probation violation. Welcome, Anthony. Thanks so much for being with me today.
Thanks so much for having me again, Lisa. Nice to see you again.
Anthony, what actually constitutes a technical probation violation in Massachusetts, and how does it differ legally from a substantive violation?
So a substantive violation would be something like picking up a new criminal charge. General Order 1 of probation in the Commonwealth of Massachusetts is that you may not be charged with a new offense during your probationary period. A technical violation might be something like failure to go to an office visit, failure to complete a class, like if you're on probation for an operating under the influence, then you didn't do the drunk driving class, testing positive for a substance that you're not allowed to have during probation, like drugs or alcohol, if that's been a condition. Those would be technical violations.
And then are there specific defenses for willful versus unintentional violations, such as failing to pay restitution due to a genuine financial hardship?
Actually, yeah, specifically that one, there's actually a case that is directly on point. It's called Commonwealth v. Henry. It came down several years ago. The Supreme Judicial Court ruled that a probationer cannot have their probation extended simply because of an inability to pay a fine. They are entitled to a hearing about their ability to pay. And since that case came down, most judges actually conduct that hearing on their own fairly early into probation so that they can make a determination right at the beginning of whether or not this person is going to have an ability to pay. Now, obviously, that can change over the course of probation. A judge at the beginning might say, well, you have an ability to pay, so you have to pay over the course of probation, and then you lose a job. So there are absolutely defenses for unintentional violations.
And then what are the specific due process rights a probationer has during a Massachusetts surrender hearing?
So you have a right to counsel during any kind of probation violation hearing. You have a right to have the charges provided to you in writing. You have a right for a judge to have probation convince them that there is probable cause that you violated one or more conditions of your probation, which is a much lower standard than most other proceedings in the criminal courts. Probable cause is just whether a reasonable person reading the facts might suspect that something happened. It's a fairly low standard, but you do have the right to have that determination. And then you have a right to a hearing on whether or not you would be released pending a final surrender hearing or held pending your final hearing.
And then what role does a probation officer's personal recommendations play in the judge's final sentencing decision?
So even if probation and your defense counsel have an agreement, it is instructive only. If you do stipulate that you're in violation, the judge will tell you the same thing I tell every single client before they sign that stipulation. Even if probation and I have an agreement, the judge has the right to sentence the defendant up to the maximum penalty for each charge that they are charged with. They do not have to do it concurrently. They could do it consecutively. And they are not bound by any recommendations. And once you've stipulated that you're in violation, you cannot take it back.
Wow. Anthony, what happens at the initial surrender hearing? And is it possible to be held without bail before a final decision is even made?
It is absolutely possible. It will very much depend on the nature of the violation. It's important. You'll be assigned an attorney, particularly if the probation department is asking for you to be held pending a final hearing. Your lawyer will talk to you about the nature of the alleged offense. So it's really important to know at that stage for your lawyer to know everything about the offense. So let's say the offense is picking up a new domestic violence charge. It's important to know, was the original case you were on for domestic violence? Is it the same alleged victim? Was it a completely different charge? What's the person's history of not showing up to court, or what we call defaulting? If the person consistently doesn't show up to court, then the likelihood is higher that the judge may say, I'm holding this person pending a final hearing because they typically do not come to court, and now they are facing potential jail time, so they have every reason not to come to court. Generally, it's not bail on a probation. It's either held or release.
And so if a judge finds a violation occurred, what are the different disposition options that they can choose besides sending someone to jail?
As many as your lawyer is creative. Realistically, it's very important to understand the judge you're in front of, the nature of the violation. So if the violation is drug related, I had this actually a few weeks ago. I had a defendant who had tested positive for cocaine. It was his previous drug of choice. He was on probation for a distribution charge. And because we had gotten him into treatment before he came in for his probation violation, the judge accepted probation's recommendation to just what we call admonish, or slap him on the wrist and say, don't do that again. But if you go in there with no other options for the judge, then you're really leaving the judge with very little choices.
And then how do Massachusetts courts handle probation violations that are based solely on new criminal charges that hasn't been proven in trial yet?
So General Condition 1 only requires that you be charged with a new offense. You can go to trial on that charge and be found not guilty. There is no defense to picking up a new criminal charge, other than that the new charge does not have what we call probable cause, as I mentioned earlier, a very low standard. So realistically, if you have been charged with a new offense, it does not actually matter whether or not you are ultimately found guilty. What only matters is whether or not your lawyer is able to argue that there wasn't probable cause for you to be charged in the first place.
Can you define compliance credits for us, and how can a violation notice impact the time someone has already earned towards finishing their probation early?
So compliance credits are credits that you would get for being on probation during what we call a split sentence. So a split sentence might be something like you're sentenced to 2.5 years in the House of Corrections, 6 months to serve, and the balance would be suspended for 2 years of probation. So after a year of probation, you would start getting about 5 days per month of, quote, good behavior off of that ultimate sentence if it were imposed. Now, realistically, the clock stops if you are charged with a probation violation, and those good days that you've been earning can be forfeited.
Can you bring this together for us? Do you have a case maybe that you recall that you could share with us, an example?
Yes. So I actually did have a case fairly recently where my client had picked up a tested positive for fentanyl while on probation on a split sentence. It was exactly 2.5 years. That was the example I was using. He had served 6 months. He had been on probation for a year, and the probation was looking to revoke the credits that he had. Again, like I said, your defenses are as creative as your lawyer can be. I did have him attending treatment programs at the time of the final hearing. I did argue to the judge, as I always do, that rehabilitation or recovery is a journey. It is a lifelong process, and people are going to slip up. People are going to fall. And as long as they get themselves back up, we should give them the benefit of that. The judge, thankfully, in that case, didn't take away his credits. She admonished him because he took the time to actually try to show the court that he was serious about his sobriety. So that is the number one thing. If you do have a violation, it's important to know the nature of the violation and how you can most effectively present to the judge that you take the violation seriously and you intend to remedy it.
And I think it probably is up to different judges on how they respond to things, but are there more than just second chances? Is there a limit to how many times a person can continue to come back and renegotiate or try to preserve those credits?
There's not a limit. You are correct. It's absolutely judge dependent. It is very important to know the judge you're in front of. So there's one judge I'm thinking of right now who comes down like a hammer on anything domestic violence related. And if you are before this judge, on particularly if it's a domestic violence event with the same alleged victim from your first domestic violence event, you may not even get one chance. But it really depends on your judge, the facts of what happened, and what steps you have taken to demonstrate to the court that you are committed to remedying what has gone wrong in your life and brought you before the court in the first place. Probation is about redemption. It's about trying to prove that you want to change the direction of your life. And if you go in there just saying, I didn't do it, no, I'm not taking any ownership, then you're going to, the likelihood of second chances diminishes substantially.
That makes sense. And then, Anthony, when should a defendant consider stipulating to a violation rather than fighting it or contesting it in a hearing?
So the number one, I usually have conversations with clients regarding stipulating, would be picking up a new criminal offense, because all the probation department has to do is demonstrate that you picked up a new charge. You don't have to be guilty. Stipulation is helpful depending on the judge you're in front of, and you may not want to stipulate on day one. You may want to get a further date and stipulate down the line where you might have a different judge. Because, so for instance, that judge I mentioned, if I have a defendant with a domestic violence probation violation, I'm not going to stipulate in front of that judge, because my ability to convince her that she should be lenient is very difficult. So judges want to hear from the defendant that they are committed to rehabilitation. So stipulation helps in that way, because you're not saying, I didn't do this, prove it. You're saying, look, I made a mistake. I don't want to do it again. Give me another chance. But you really have to know your judge. You have to know your client, what the violation is, what their history is. If they're on every case they've ever had, if they're constantly violating probation, you may want to not stipulate and force the probation department to prove that.
Anthony, let's wrap this up. If somebody listening finds themselves in a situation where they have broken probation, what's their first step? Where should they start? How do they get help?
Well, the first thing that they need to do is contact an experienced attorney, because they will work with that lawyer to develop a strategy on how best to handle that with the court. They should make sure that they're fully upfront with their lawyer about the nature of what happened. Are there reasons? If it's a drug offense, have they started getting in treatment? How severe has the drug offense become? Are they constantly using again? Do we need to get them into a detox program? It's all about what happened and what is going on in their life, because presenting the reason why it happened is more important than the fact that it happened. Being able to explain to the judge, I had a person who tested positive for alcohol who very easily could have just said, I tested positive for alcohol. But once we got into the why, his father had just died. He was a person with a substance use problem. He was a recovering alcoholic, and he slipped up because his parent died and he drank. And I was able to present that to the judge as more than just, yes, you're right, there's a positive alcohol screen. It was, yes, there's a positive alcohol screen. However, this person is in treatment now. This is why he slipped up. So it's really important to be able to present the whole picture to the judge, not just the fact that it happened.
And I think we'll leave it there today. Folks, if you find yourself in a situation where you violated your parole, there is help. Please reach out. That's it for today's episode of Law, Life, and Liberty with attorney Anthony Puopolo. To learn more about Anthony G. Puopolo II and his work across Massachusetts family and criminal courts, visit agplawoffices.com. Thank you so much for listening, and don't forget to subscribe, share, and leave a review so more Massachusetts families can find the guidance they need. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.